Hello. Hello everyone, my name is Sarah Bruce and I'm a 3L at Tulane and I'm also the senior online editor for the journal. My comment in the upcoming volume 43, issue 1 is entitled Stranded on the Dock of the Bay, the Fifth Circuit's Recognition of State Law Attachment Statutes to Seize Property Before Arbitration. My comment actually evolved from my case note and focuses on the case and the implications of the Fifth Circuit's ruling in StimCorp USA versus COSAPAR. And this case has continued to evolve ever since its first Fifth Circuit decision in the fall of 2017. In my comment, I go through the basic applicable legal frameworks of arbitration and attachment through the New York Convention on the recognition and enforcement of arbitral awards, as well as through the application of state non-resident attachment statutes under the New York Convention, which are both helpful for maritime practitioners seeking writs of attachment before a judgment is rendered in arbitration when they find themselves in federal court, not by way of admiralty jurisdiction. In StimCorp USA, the Fifth Circuit interpreted whether Louisiana non-resident attachment statutes allowed for pre-award attachment in a suit not maritime in nature, pending arbitration proceedings. In short, they do, as long as they are seeking a money judgment in the arbitration. Some relevant background on this case so we can see how this attachment conundrum began. And I understand there are a few attorneys in this room who know a lot more about this issue than I do. The plaintiff appellant and defendant both filed separate legal actions against American Metal Trading, AMT, which is a subsidiary of the Brazilian pig iron manufacturer, COSAPAR. They both filed these their claims and subsequent writs of attachment for breach of contract regarding the purchase of pig iron to be delivered in New Orleans. Daewoo International Corporation, Daewoo, is a South Korean trading company, and they alleged a breach of contract claim with AMT for failure to deliver certain cargoes of pig iron. They filed suit in the Eastern District of Louisiana to compel arbitration and ordered corresponding writs of attachment on the pig iron under maritime law. However, they soon amended their complaint to seek a writ of attachment under Louisiana non-resident attachment statutes. The district court granted the writ of attachment. At the same time, Krupp, which is a German company, intervened in Daewoo's suit and filed suit in Louisiana State Court against AMT, also for breach of contract. Their writ was also granted. TKM, then Krupp, then moved to lift Daewoo's attachment, and the court ruled for Krupp and held that the state attachment statutes do not allow for attachment in aid of arbitration, as Daewoo had applied them. Daewoo appealed. So the issue became who in these corresponding claims and attachments on the same cargo had the right to the pig iron. Daewoo, who filed their writ of attachment first, but using state law attachment statutes under the New York Convention, or Krupp, who sought to vacate the attachment, the invalid preceding attachment, Daewoo's attachment. One of the issues the court spends a lot of time discussing is the traditional legal framework of attachment in maritime cases. As we know, federal courts have original jurisdiction over admiralty in maritime cases, including issues involving arbitration. Within the federal rules of civil procedure, the supplemental rules for admiralty and maritime claims provide a statutory basis that explicitly controls the issues regarding attachment, known as Supplemental Rule B. However, Supplemental Rule B of the Federal Rules of Civil Procedure allows the plaintiff to use state law attachment statutes for the seizure of property in order to secure a judgment. In 2010, the Fifth Circuit decided in its decision in Alphamate that an arbitration dispute concerning the sale of goods, the contract for a sale of goods, was not wholly maritime in nature and did not fall into the admiralty jurisdiction, therefore prohibiting the use of Supplemental Rule B. This doesn't necessarily bar claims not maritime in nature from making their way into federal court, as federal courts can still obtain federal subject matter jurisdiction using the New York Convention on the recognition and enforcement of arbitral awards. When a claim falls under admiralty jurisdiction, courts can use Supplemental Rule B. However, when it's not maritime in nature, the court can receive subject matter jurisdiction under the New York Convention. The New York Convention allows for federal subject matter jurisdiction in certain circumstances when 1, there's an arbitration or award that falls under the convention, and 2, the dispute is in relation to that agreement. Specifically, the Fifth Circuit held in east of Stamford, Connecticut, that the Federal Arbitration Act allows a party in an admiralty case to employ traditional procedures like the attachment of a vessel to obtain security for arbitration, and that doing this in advance is not inconsistent with the New York Convention. Other jurisdictions have held consistent with East and the Fifth Circuit. So, if you have a claim in federal court through the New York Convention, the Fifth Circuit held in STIMCOR that you can employ traditional procedures like state attachment statutes to aid in arbitration. Regarding the Louisiana state attachment statutes used in STIMCOR, the two applicable statutes discussed by the Fifth Circuit are Article 3542 and 3502. 3542 allows the writ of attachment to be obtained in a money judgment, and 3502 allows the attachment to be issued before the arbitration. The first, Article 3542, states that a writ of attachment may be obtained in any action for a money judgment, whether against a resident or a non-resident, regardless of the nature of the character, the origin of the claim. This explanation, Louisiana state and federal courts have thoroughly explored and defined an action for a money judgment, and this exploration is more thoroughly discussed in my comment. But this is the contested issue of the case. In the present case, the Fifth Circuit determined that an action for money judgment is a civil or criminal judicial proceeding seeking monetary damages. The Fifth Circuit confirmed that while a suit to compel arbitration is not a direct action for money judgment, confirmation proceedings to convert an arbitral award into a money judgment do fall within the statute and can be properly used to issue a writ of attachment. In STIMCOR USA, although the court decided that Daewoo's action did not directly seek a money judgment, they can apply the second Louisiana statute, 3502, in order to properly attach the attachment in aid of arbitration. If the party seeking an attachment in aid of arbitration, 1, complies with the procedural elements of 3502, and 2, shows good cause for pre-petition attachment. The court held that although Daewoo's suit to compel is not an action for money judgment, Daewoo followed the procedural requirements of Article 3502, and it was clear that they would be seeking a monetary award against AMT during the arbitration. Therefore, the court held that the attachment was valid under Louisiana law and through the New York Convention. Subsequently, Dyson Krupp moved for a rehearing in which the Fifth Circuit reversed their decision, keeping the same logic, but decided that Daewoo had not followed the procedural requirements of Article 3502, and thus were not entitled to the writ of attachment over the pig iron. There are many implications of this Fifth Circuit decision, and I feel like now is also the time to tell you that less than a month ago, on October 17th, the Fifth Circuit decided to re-examine this issue after separate rehearing petitions from the parties, as for the meaning of the phrase, action for money judgment. They stated that this judgment carries significant consequences for both state and federal commerce. They have requested that the Louisiana Supreme Court resolve this issue, and as of today, we're still awaiting on whether the Supreme Court has accepted or rejected this request. However, assuming that the Fifth Circuit's logic is sound, the ability to use state law attachment statutes provides maritime practitioners with both practical and legal advantages in their cases, whether they find themselves in federal court under admiralty jurisdiction or through the New York Convention. STIMCOR USA changes the possibilities for allowing state law attachment statutes in the Fifth Circuit by providing a loophole to the previously mentioned 2010 Fifth Circuit decision in Alphamate, in which they held that an arbitration for a dispute for a breach of contract for a sale of goods is not wholly maritime in nature, and thus you're not allowed to use the supplemental Rule B attachments. If the logic in STIMCOR USA is sound, maritime practitioners in a post-Alphamate world could invoke state law non-resident attachment statutes when supplemental Rule B does not apply. Looking to other states with attachment statutes similar to Louisiana, New York has specific legislation providing for pre-award attachment in aid of arbitration and could follow the logic of the Fifth Circuit in applying these statutes. Florida state resident attachment statutes also allow for attachment when the property in question falls outside admiralty jurisdiction. However, they impose stricter conditions on the malevolent actions of the debtor, and likely that given the opportunity, the U.S. Court of Appeals for the 11th Circuit might not rule in the same way as the 5th. As long as arbitration continues to be a preferred method of dispute resolution among maritime practitioners and their clients, the Fifth Circuit's decision in this case, allowing the attachment of property before pending arbitration, will aid in the resolutions. As arbitration and claims with mixed contracts not wholly composed of maritime issues continue to arise, circuit courts will have to provide legal remedies for these problems. If other jurisdictions follow the Fifth Circuit's reasoning and conclusions regarding state law attachment statutes in aid of arbitration, there will be a boom in attached goods waiting at the dock for someone to claim them. Thank you.